So, if you've just found out that you're the executor of a loved one's estate in Michigan, you might be wondering what that really means, especially when a home is involved. Today, I'm sitting down with Nick Lydorf, who specializes in probate and estate law, to walk through some of the key responsibilities executors, or the other term you might hear, personal representatives, need to understand. Why don't you go ahead and introduce yourself, Nick?
Hey, thanks, Alex. Yeah, my name's Nick Lydorf. I'm a estate planning and probate attorney here in Michigan. I'm offices in East Lansing. I've been practicing for almost 20 years. Sounds like forever, but it's something that I've been doing for quite a while now. Yeah, and I like help people navigate through this process and trying to figure out the best ways to handle it without any kind of common mistakes, things that people make, and get them through this as easy as possible.
Awesome. Yeah. Hey, I also found out you're a comedian on the
Yeah.
side. So,
Yes. Yep. Been doing that for 12 years and releasing a book in October. So,
oh, nice.
yeah.
Okay.
Yeah.
All right. So yeah, and those who don't know me, I'm Alex. I'm a real estate agent licensed in Michigan, specializing kind of in the Lansing area with probate estate homes, or really what I call life's transitions. So whether that's moving mom into long-term care or those sorts of things, and you need real estate handle, I'm your guy. So without further ado, let's go ahead and dive right in. I think the best place to start is just with simple definitions. And again, we'll assume nobody's ever watched any of our videos. So give me a straightforward, plain English, non-legalese, non-jargon sort of a
Yep.
definition. When we say executor, what are we talking about?
Yeah. It's basically somebody that's going to act on behalf of your estate. So we call that a fiduciary. It's basically you're a representative of the estate and you have to act in the best interest of the estate.
Absolutely, yeah. So I think that's a kind of a key word, that fiduciary you'll probably see come up like often over and over again, and I think that's a fancy word to say that, to keep in mind that that's just acting on the behalf of the estate. And I think let's kind of dissect without getting, I guess, too deep into it, because sometimes there's crossover between being an heir, a
Mhm.
beneficiary, and an executor, and those terms can kind of get confusing because we can all like an individual may be an heir, a beneficiary, and an executor. They may only be an heir and neither a beneficiary or an executor. And so, kind of like, can you dissect for me, specifically looking at heir and executors? What's the difference?
Yeah. So basically, an heir would be somebody that is, for instance, named in a will. And that would be somebody that's just going to receive a proportion or just a share of someone's estate when they die. Um, and then, yeah, that's pretty much what that is. It's just could be your children, could be grandchildren, could be other people that are named that are not in your family.
Right. And so I think that's kind of a good point to mention, is that your executor doesn't necessarily have to be a family member, although obviously it's probably common that it is. Usually it's the children, or maybe a relative like a sibling or something like that. But it's definitely possible for you know to name a personal representative or executor that's not even actually family at all, right?
Right. Right.
How, I don't know how common it is for you, but how common would you say it is that maybe an attorney or a different kind of professional represents the estate as an executor?
Yeah, yeah, a lot of see that about maybe one out of every 20, maybe something like that. You would see that usually for people that maybe their children, they don't have any children, maybe they're not married, they don't have a deep bench of people that they can choose from to handle their estate. So yeah, it's not that common, but there's also you can name much more prevalent back in the day was naming banks and credit unions as like personal representatives and executors of estates too.
That'd be a little scary. I can't believe people would do
Yeah.
that.
I know for sure. For sure, definitely. Yeah.
But I,
Yep.
I guess banks had a little bit more maybe ethics back then.
Yeah, for sure.
Uh,
Yep.
awesome. Yeah, I think something we should highlight too is that when we may use interchangeably the term executor or personal representative. I know from previous conversations that you and I have spoken that personal representative is definitely kind of the more term you're likely to see. Obviously in probably the legal documents and through the probate process. So we're really, when we're saying executor or personal representative, we're essentially saying the same thing.
Yep.
Yeah.
100%.
All right. And so I kind of want to break down, I think let's break down sort of the main duties first of an executor. And I think let's I think the most logical sense, unless you have a different idea, is let's talk about the executor's duties from a timeline perspective. So
Yeah.
opening up probate and kind of moving forward through that process.
Sure. So, um, the person passes, the decedent is now dead, and the personal representative is named in the will, let's say. So then what they're going to do is there's a series of forms that they're going to have to file that are standardized forms within the state of Michigan. And they're going to file those forms, and then they'll attach the original will with those initial forms. The Typically what will happen is the probate register will then sign some appointment documents that will appoint the individual as personal representative. And then from that day forward, there's a series of deadlines that are going to happen throughout the probate process. There's one of the initial ones is going to be an inventory of the estate. That's going to happen within 90 days of someone being appointed as personal representative. And there's a couple different sets of timelines that'll happen, but that's usually the first one that's going to trigger. Another one's going to be um, notifying creditors, usually putting a notice in the state journal. That's going to be one. There's no set date for that, but the sooner you do it, the sooner you're going to be able to close the estate. So probate is really for the creditors of the decedent. So that's kind of why it's all set up. And you have to give enough notice to the creditors. In this case, it's going to be 4 months. So from 4 months from when you publish that notice to creditors in the paper, the creditors are going to be able to respond and file any claims against the estate. So that's another important one. Want to get that one done as soon as possible so that 4 months can run and then you can close in a timely manner. So one of the laws says you can't close an estate shorter than 5 months from when it was open. So within that first 30 days, you want to try and get that published with the state journal. Then deadlines throughout that are beyond that. After you file the inventory, there's going to be an inventory fee that's going to go to the probate court, and that's going to have to be paid at the time you file the inventory or within 1 year of the close of the estate, whichever comes sooner. So you don't necessarily have to pay the inventory fee when you file the inventory, but you either have to pay it within the soonest of 1 year or whenever the probate estate is closed. So kind of a couple different timelines that are set forth there. And those are actually the ones that are set in stone with the statute, but there's some other ones I'm sure we can
Sure,
get into.
absolutely, yeah. So obviously, let's
Right, right.
I kind of want to simplify it,
Sure.
just as a summary version of I think what I
Yeah.
heard is obviously our main responsibilities are, they got to open up probate. That's one.
Yeah.
That's step one, and there are timelines and due dates associated with that. We need to inventory all of the assets, which I think that's usually where you and I kind of intersect a little bit more about the
Right.
inventorying and the handling and management of assets. So I'd like to obviously dive a little bit deeper into that coming up. And then the third thing is kind of handling, responding, notifying the creditors. And I guess you could say the last one would be, everything associated with closing probate, distributing, the assets, taking care of the taxes, et cetera, those kinds of things. So I kind of want to dive a little bit into inventorying assets. I think. Well, before I do that, I do want to back up. Let's go back to opening up probate. Now, if I want to open up probate and it just occurred, I think maybe there's maybe some confusion. Or at least misunderstanding. Or the question is, where do I open it up? Where do I file? If I live, let's say, in Ohio, or I don't know, maybe I live in Kent County or something like that, and my relative, or the estate is located in Ingham County, where I'm, handling the probate process. Would I file any county with the state, any court, that kind of thing?
Yeah, so you'd have to file it in the county where the decedent was domiciled or residence. So that would be in this case Ingham County. So that's kind of where I people reach out for help is because we're in this tri-county area. We get a lot of calls from people that may be either out of state or that are from Grand Rapids, Flint, Detroit, and we can assist those people with the probate process. We handle things all over the state of Michigan, but we get a lot of calls from
Yeah,
people for help in
absolutely. Yeah, it was. I was doing some research, and I don't, it was kind of pulling some data, and I know the data is a little bit hard to necessarily accurately predict, but I think in the estimations and the estimates that it says like 1/3, I believe, of the estates that are filed, like in Michigan, they're over an hour away or they're out of state, basically. So that means, almost 30 to 40% of people are managing a probate estate, not even living near the where the estate is located and where it needs to be filed, which can create a lot of obviously issues if you have to go down to the courts, or if or if you have physical hard assets, right, like real estate to manage property.
for sure.
Yeah. So I wanted to kind of talk to about, I guess, inventorying assets. Let's talk about that. You mentioned the 91 days or 90 days, and so I guess one question is, when we inventory assets, what should be included? I think there's the obvious stuff, but what about some of the smaller stuff, jewelry, art, cars, those kinds of things?
Yeah, so definitely anything that has like a significant value, we want to try and inventory that as much as possible. And there's a lot of leeway that comes along with that in the discretion of the personal representative in terms of how do we value some of these things. Like it may not make a lot of sense to value things like maybe costume jewelry or things like that. Typical cars, maybe you just want to get the book value of that. Maybe antique cars, you may want to get things like that appraised. And so basically just trying to do what we go back to what we talked about earlier about on behalf of the estate, you're trying to act in the best interest of the estate. And we're trying to marshal all these assets, get everything together and put together some sort of valuation of these important kind of assets. Things like clothes, pots and pans. Those can kind of be lumped into maybe a specific category of like household items, clothing, things like that. And you can kind of assign a value to that as the personal representative.
Yeah.
Yeah.
Yeah, absolutely. And then, yeah, like you mentioned, like getting a more of a praise, like a car. I think if it's a, old car or a vintage car, definitely getting the more of the appraisal value. I think that kind of applies to houses depending on where they're going. They may need to get, like a Zestimate or, a market analysis may be fine, or they may need a more qualified, real estate certified licensed appraiser in Michigan, depending on the situation. So.
Right.
Let's kind of shift a little bit to some of the mistakes maybe that you see, maybe acting without letters of authority or those kinds of things, maybe neglecting the maintenance cost of an estate. What are kind of sort of some of the mistakes that you see executors make most often when it comes to probate and or the family home?
Yeah, so I think the one thing that we've seen when I've taken over probate estates from people that did it on their own is they didn't publish that notification
Mm.
in the paper, usually state journal, and then that's just going to further delay the closing process. So um, that's one thing that I definitely see people not doing. Another one would be maybe not taking into account the sometimes the will provide for the personal representatives to compensate themselves at a reasonable rate for times, and it can be taxing and time consuming. So that's maybe one thing that we'll see um, people not compensating themselves, so acting as personal representative. Um, and another one would be not listing things like mortgages for real properties or houses on the inventory fee. So inventory. So that's houses are one asset that you can deduct like a mortgage from the total inventory value. So the goal for the estate would be to pay the small amount as inventory fee as possible. So I've seen people not include mortgage amounts, and then that has their inventory fee maybe double triple than what it would normally be, and then that's just going to further reduce the compensation to the heirs when the things get paid out. So
Yeah, absolutely. So obviously we have in a way self-serving interests, but we're actually really out to help people. And so I know when we say like there kind of is a cost to this DIY approach. You may think that you're saving money then in that case, but now you're paying a higher fee to either in the inventory cost or maybe even having to redo everything.
Mhm.
Or like you mentioned, the delays in probate, because earlier we mentioned that the creditors have to be notified and they have to have a certain amount of months of notification. So if you fail to publish that in the paper, you're really kicking the can down, and that's just gonna eat into the cost of probate. So I would say like obviously with that being said, in which cases do you recommend or never that anybody handles probate on a DIY
Yeah.
basis?
I think if you're maybe a financial professional and I think maybe that you probably feel more comfortable doing it. But other than that, I at least reach out and talk to somebody that's familiar with that area because it's going to eat up a lot of your time and it may be more cost effective to hire somebody to handle all this stuff for you, which I think it usually is. So yeah, that's kind of what I would recommend people do.
Absolutely. Yeah. And we talked about eating up time. Let's try to I know there's going to be so many variables that it's going to factor into, but what do we think that an executor can expect on a weekly basis to spend on handling the probate process?
If they're doing it on their own, I mean, they're probably going to have probably a significant amount at the beginning to try and learn what the rules are. The court's not supposed to tell you. They're not supposed to give legal advice, so you're kind of out there on your own unless you're kind of trained in this area. So you're gonna have to like, you know, maybe read you know, books about it or articles about it or watch videos like this one and trying to figure out how to
Okay.
navigate through all this stuff. So yeah, you're probably gonna have maybe 5 hours a week of your time that you're probably gonna have to devote to things like this, and that can definitely add up. Um,
Yeah. Would you say that like probate tends to be kind of front loaded because we talked about all the stuff that has to be done really early on, inventorying assets, notifying creditors, opening up probate. And so it's kind of like it's a almost like a sprint for those first 90 days, and then it's like a sit and wait game until the courts
yeah,
process everything.
for sure. Yeah, I
Yeah.
know that's it's definitely one of the front loaded things. Yeah.
Yeah, absolutely. So let's talk about a little bit of the financial, I think, management or obligation. I think obviously sometimes the states may not have cash, and they may have equity or they have assets, but they may not have cash. And so I think I kind of want to talk about. I'll separate this in a couple questions. First
Sure.
is how do what kind of expenses or ongoing expenses might somebody expect if they were managing an estate? Obviously, and we'll assume, like most, they have real estate. What kind of expenses on a monthly basis can we expect to pay that the estate would be responsible for?
Yeah, so things related to utilities. If it's in the wintertime, you gotta have some sort of, heat electric to keep the pipes from freezing, things like that. And then monthly or, on a tax basis, you've got your summer, winter taxes. You're gonna have to definitely pay those. And like you said, if the state doesn't have assets, where they're going to get that may come down to the person representative or the heirs trying to keep things afloat until they decide maybe when to sell real estate, things like that.
Absolutely, yeah. So I think that kind of leads into the next question is like if an estate doesn't have the cash, how can we pay for it? Obviously, we kind of mentioned selling some of the assets to free up cash. What if we can't quickly free up any cash? I think there's obviously a concern of, hey, how do I budget for this, and am I going to get this money back? Because
Yeah.
there's probably also a misconception that any money that I put towards maintaining the estate, I'm not going to get back, or I'll get back when I receive my inheritance.
Okay. Yeah. So any expense that like the personal representative or someone else decides to chip in to keep the estate, afloat to maintain those assets, they're going to end up getting that back, and they're going to get it back have priority over other creditors. So it's bring me assured that let's say you sell the house, there's going to be equity from that. They're going to get paid out first, rather than any other creditors of the estate. So
Okay, yeah. Yeah, and I think that's important. I don't know if you run into it. I'd be curious to know if like I mean, do you find that people don't really end up keeping good records financially and then therefore they don't really ever end up being reimbursed for the expenses that they paid to keep the estate afloat?
yeah, I mean, we always tell our clients when we're going through it, we got to start from day one, so we don't have to kind of go back and may miss some things. But yeah, I when we've taken over um, cases from people that have tried to do it on their own, they often forget certain things, and we definitely try and well, at least 2 or 3 times trying to say like send us anything that you've done previously so we can try and make sure that we get all this together so that you can get reimbursed for any of these things before things are paying out, creditors are paid, things like that. So
Yeah, I think that's too like the importance of starting early, and getting talking with a professional early because I mean, yeah, if you definitely sit around on a estate, a home, or any of those assets for 8 months before you're even opening up probate, there's a lot of expenses there that you may just forget about or chalk up for a loss. What if I don't want the job?
yeah.
Sometimes people get named in wills. Nobody talks about what's in the will, and then you find out upon the death of a loved one that you're in the will or as the personal representative. So, what does somebody do who doesn't want to be a personal representative?
Yeah, so it may be a job that you don't want. So, and that's fair. And it can be a lot of work. So there's ways that you can renounce your nomination to act as personal representative. You're basically just saying I don't want it, and then it can go to maybe the next person in line if someone's named in the will. If not, then there may have to be a hearing in front of a probate court judge where maybe one or multiple people are vying for this job, and the probate court would have to make a determination of who's best suited to handle that. So that's kind of what.
Absolutely, yeah. And could you explain a little bit? Because I think there was two. There's maybe somebody thinks they want it at first, and then they get a little bit down the road and they realize they don't want it, and so the
Yep.
court's actually already appointed them as the personal representative. So I think let's talk about renunciation versus maybe
Yeah.
resignation, and kind of where that line is, so somebody knows if they're a personal representative.
Yeah, like if they're personal representative and they want to resign, that's definitely possible too. Um, it would be cleaner if there's somebody that would want to take over, and then you would just kind of show up at a hearing, and the court would make that determination. If not, then you're going to have a hearing, and they're going to have to determine who's going to take over this position. If you want to resign, it's probably going to be in your best interest to show up at that hearing and have somebody ready to take over, because the court's probably going to be like, well, why you kind of wasted our time with saying that you wanted it. We understand it's a big job, but now we have to try and track somebody down that is going to be able to eligible and want to fill this role.
Okay. Yeah, yeah. And so I think too, we talked a little bit or at least mostly focused on assuming that somebody's been named or there was a kind of a will left over for somebody to be named a personal representative.
Yep.
And so let's shift if there is no will and we kind of have to follow the laws of intestate and stuff like that.
Yeah, so there's going to be certain priorities of who's going to be named, and it basically has to do with, if you leave a surviving spouse, if you have children, maybe if you don't have children, then you have parents, you have brothers or sisters. So you're kind of going down these different um, default rules that the state of Michigan has for who's going to be eligible to serve as your personal representative if you didn't name one or didn't have a will.
hmm And do you ever recommend like a group of siblings kind of being the personal representative all at once?
No, no way. Definitely not. I think that just is like just invites conflict. I mean, if you're kids and you didn't get together, then like, fighting over things, potentially like money, probably not the best thing that you're gonna want to do. And the whole point is this is trying to get you through this as quickly as possible.
Mhm.
Um, and you can always challenge what a personal representative does. You have the ability to do that. So I think there's definitely checks and balances on this, and putting more than one just slows down the process of trying to get these things done as quickly as possible.
Yeah, and we kind of talked about it in our the probate basics video too. And I think if I understood this correctly, that and correct me if I'm wrong, because I'm going to try to phrase this correctly, is that the renunciation of your right to be personal representative is not the same as a renunciation to an inheritance.
Yeah. Yep,
Yeah,
exactly right. Oh yeah, so they break it down into who's going to act as personal representative, and then you can renounce your right to serve as personal representative. Let's say there's two siblings. One decides they don't want to be personal representative, and they're okay with the other sibling. That one will then renunciate their right. So to say their brother or sister would then serve as personal representative. That has nothing to do with their right to inherit from mom or dad's or whomever's estate. So that they would still get the same share as anybody. Um,
absolutely. I imagine that would be, I don't know if you see that a lot. I imagine that would be a common barrier of like, no, I'm not renunciating my right to be a personal representative. And then you end up with multiple siblings all trying to be personal representative because they're
right.
afraid that they're going to lose out on the inheritance.
Right.
All right, let's see here. I also had a question or kind of wanted to talk about in terms of diving a little bit deeper into those who are personal representatives, maybe what tips or mistakes you see for personal representatives who are out of state or living a good sizable distance from the estate and where probate needs to be handled.
Um, yeah, people that do it on their own. One thing would be not serving the other heirs or people that maybe um similar situated to them. So like named in the will as beneficiaries or are heirs, maybe not providing adequate notice to them, like of the inventory. Um, so those are the things that they maybe not do. If you're around some of these people, you would provide service to them, maybe just by handing those documents to them. But if you don't know how to serve people, it's basically just providing them documents, and you have to account for you doing that. Um, that's probably one of the things that we see from out of state people that have made some mistakes and just not given these documents
Yeah,
to
that makes sense. And then another question that kind of pops in my head, or that I'm always curious about too, and that I kind of run across is because people will try to pass off real estate without probate, right? So we're gonna
Mm,
pass it off through a ladybird deed, or what do they call them, the survivorship and stuff like that.
sure.
And however, there's usually still, let's assume there's a mortgage on it, maybe there's that assumption that, hey, I passed off the house, the mortgage disappears with the death of the
Mhm.
loved one. And so it's kind of, you're almost in this like catch 22, I guess, is that the house may be bypassed in probate. However, the mortgage is not. Do you want to kind of like, I don't know, I guess explain that process, or maybe what tips you might give to somebody who is kind of experiencing that or sees that?
Yeah, it might be something that they thought maybe the house was passed off, and then they receive the home, and then they get maybe a bill from a mortgage company, and they're like, well, what's this? And so, yeah, that's something that we've definitely seen, and that's kind of when we'll reach out to like someone to be able to possibly sell the home because it's just too much to take on. Maybe they have another home already. Um, and so there's still, while there's no probate, there's still some lingering things to kind of take over with trying to deal with this mortgage. Um, there's problems that, like, let's say you got a child or someone that lives with you, and you passed, and then they're still living there. There are ways that they could assume the mortgage, but maybe the rate was better than what it was now. But there's certain things that they have to qualify for to be able to assume that without having to refinance it into their names. That's definitely problems as we see with like the market now versus you know 5-10 years ago. So
Right. Yeah, yeah, absolutely. Yeah, I think I've come across that kind of sometimes is yeah, where people will be, they'll end up going through probate. There's enough assets to pay off and settle all the debts, so they're able to keep the house past probate. At least those are the good ones that I've usually usually run into that they're contacting me after the fact. But it's definitely like a thing where I've seen it that the house hasn't gotten into probate. They passed it off on a ladybird deed or something like that, and but however, they still had to use all the other remaining assets to pay off and satisfy the debt, such as the mortgage. So yeah, that sounds pretty good here. I think let's just kind of leave with I guess uh, your simple message, last piece of advice that you would give to anybody who's stumbling and hopefully made it all the way all the way through our lengthy video.
Yeah, yeah. So I would say just reach out for help. I mean, if it's not your wheelhouse, definitely try and talk to somebody that's been through this process before and knows how to sell real estate, knows how to navigate through the probate process. It can be, a 5 minute, 10 minute phone call and we can kind of get you back on the right track. Or if it's just like, hey, I'm pulling my hair out, can you take this over for me? We've definitely I've been through both of those conversations and I think it's beneficial to just get help from people that know what they're doing.
Yeah, absolutely. I think that I would almost piggyback on that too. It's like or like add to, even if you almost have experience, especially if you don't live in the area, it's probably better to still contact somebody in the area just because of those network connections that that we built, that we kind of are in this hub. And so even if you're in, Metro Detroit having or Grand Rapids having to manage a probate estate in Lansing, it can be challenging because you don't know the junk removal companies, the real estate agents, you don't know the judges and stuff, and you've built significant connections and relationships with all of the people on the legal and non-legal side of probate.